When we think of the four horsemen of the apocalypse, we imagine famine, war, death, and pestilence. A truly terrifying quartet. But in the world of business and branding, there's another and far more beneficial group of four to contend with: patents, trademarks, copyright, and trade secrets. This isn't a tale of doom and gloom, power and protection. These are the tools you can use to build your kingdom, not tear it down. What's up, everyone? Julie King from King Patent Law here. Welcome to Know Your Rights, or more aptly this time of year, Know Your Frights, your spooky playbook for intellectual property and business law. I'm going to show you how, in a world full of business boogeymen and intellectual property monsters, you're the one with the tools to survive. You won't be a victim running for cover. You'll be the final girl, armed and ready to protect your brand from the ghouls and grabbers looking to steal your ideas. When you're a creator, you're so often focused on the art, killer guitar riff, the perfect jump scare, gruesome monster, that you forget about protecting it. But letting your creative legacy fade into obscurity, or worse, get stolen, is the kind of horror story that's no fun at all to see. Don't let your creative work become a ghost story. The four main types of intellectual property. Think of these as your personal tools of terror. They're your spells, your chainsaws, your flamethrowers to get anyone who dares to rip you off. So let's pull back the curtain and get to know our four horsemen of a brand apocalypse and how to tame them. First up is copyright. This is the ghost in the machine. It automatically attaches like a spirit to every original work of authorship the moment it's created and fixed in a tangible medium of expression. This means that the moment you finish writing that screenplay, recording that song, or painting that monster on your canvas, it's yours. It grants you the exclusive right to reproduce your work and make new versions of it, distribute it, and perform it publicly. So what does it protect? Things like novels, screenplays, films, songs, lyrics, musical compositions, paintings, sculptures, and photographs. It even protects things like business pamphlets and white pages and website content, things that you might think aren't really creative enough to be protected, but they are. So what's the catch? While copyright is automatic, you need to register it with the U.S. Copyright Office to sue someone for infringement in federal court. Registration also helps with internet takedowns. Registration isn't a difficult process, but it is a critical one if you ever need to defend your work, especially in these days of zombie AI algorithms helping people steal your content. Next, we have trademarks. This is your brand monster. It's the name, logo, slogan, or design that identifies you as the source of your goods or services. It prevents others from using something confusingly similar to trick your fans into buying their knockoff junk. Think about a famous band name like AC/DC. That's a powerful trademark. It's not just two sets of letters. It's a brand that represents decades of rock and roll. It has immense value. So why should you care? Your band name, your clothing line, your spooky boutique, your film production company name, these are all valuable trademarks. Without protecting them, some other ghoul can come along, use your name, and steal your thunder. Federal registration with the USPTO, which is the United States Patent and Trademark Office, gives you nationwide rights to use against copycats and lets you use that big satisfying circle R symbol. Also, being careful with your trademarks will help you avoid the horror story that is being rightfully accused of trademark infringement. Now for the black sheep of the family, patents. Many people think they're just for the pharmaceutical industry, universities, and big businesses like Boeing or SpaceX, but that's not true. They're also powerful tools for small businesses and inventors. Think of them as your Frankenstein's monster, a new, useful, and non-obvious invention you've brought to light. What is a patent? A patent gives you the exclusive right to exclude others from making, using, and selling your invention for a limited time, usually about 20 years from the date you filed your application. So what can a patent protect? Utility patents protect manufactured items, some processes, chemical compositions, and more. While you can't patent an entire song, you could get a patent for a new guitar design, a unique effects pedal, or a groundbreaking special effects machine you've invented. You can also get a design patent for how something that's made looks, like a Halloween mask you designed. It's a lot less common, but for the mad scientist among us, patents are a critical tool. Finally, we have trade secrets. These are the secrets locked away in the haunted mansion. They're confidential information that gives your business a competitive edge. The secret here is, well, just secrecy. Unlike patents or copyrights, a trade secret is protected as long as you take reasonable steps to keep it confidential, and it remains valuable because it's secret. Trade secrets have a specific legal definition, but for secrets that don't quite fit it, they're protected as confidential or proprietary information. There are just fewer fangs in that protection than there are for trade secrets. So what can you keep secret? A unique horror makeup formula, a proprietary special effects technique, or a list of your most trusted confidential vendors. Anything really that, if it were in the hands of your nefarious competitors, would cause serious problems for you. Well, how do you protect these secrets? The best way to keep something secret is literally to lock it up and restrict access. Using great cybersecurity is smart too. Non-disclosure agreements are the do not enter signs warning you not to step foot into the dilapidated house. Keeping mouths wrapped up like a mummy is vital. Once the secret gets out, it's no longer protected as a trade secret, confidential information, or proprietary information. Poof! Gone like a vampire at a puff of smoke. Now, if someone violated a non-disclosure agreement or hacked their way into your vault, it's time to put the bite on them. So there you have it. Patents, trademarks, copyrights, and trade secrets. They may seem like complex legal mumbo-jumbo, but they're the vital tools you need to protect your art, build your brand, and turn your creative passions into a thriving, valuable business. In the coming weeks, we'll dive deeper into each of these. Until then, stay spooky, stay creative, and stay protected. Don't let your creative work or business become a ghost story. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand, you need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your art, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. And if this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe. You can find all of my other frighteningly good content on the King Patent Law website and on major platforms. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. I'm not your lawyer yet. You should not act on any information presented here without first seeking the counsel of a licensed attorney for your specific legal needs.